Sir, we are on live. Right? Madam, unmute చేశారు మీరు.
Recording in progress.
So you can go ahead.
Good evening to all of you. We start today's lecture, that is on 12/6/24. We are on the third day of lecture on Civil Procedure Code. Yesterday, to recap, we were just discussing the contents of a plaint as laid down in Order 7. Second one which we discussed was the procedure to file the documents when the plaintiff files it subsequent to the suit, that is Order 7, Rule 14(2). Then we discussed about return of plaint and rejection of plaint, that is Order 7, Rule 10 and Order 7, Rule 7. Any doubts about yesterday's lecture, please? I'll try to convince you when we finish the session. Here now we go to the next, and please remember, plaint is filed under Section 26, read with Order 7, Rule 1 and 2 CPC. Then we go to the next step, that is what is called written statement. That is in Order 8. Order 8 speaks about filing of written statement. Written statement is a document which is filed by the defendant or defendants in reply to the adjournments made in the plaint. Plaint is filed by the plaintiff. Written statement is filed by the defendant or defendants. First and foremost is, you have got a provision called Order 8, Rule 1. All written statements will have to be filed within 30 days from the date of receipt of summons. That is, on the day when the summons are served on the defendant, 30 days period is taken for filing the written statement. Then you go to the second clause, that is Order 8, Rule 2, which says if the written statement is not filed within 30 days, it can be filed within 90 days. Beyond 90 days, the court has no power to extend. But the judgments of the Supreme Court on this particular aspect is that the filing of the written statement within 30 days or 90 days is only obligatory and not mandatory. And that is right from 2004 Supreme Court, 2005 Supreme Court says except in commercial courts, the filing of the written statement within a period of 90 days or 30 days is not mandatory, because when the court feels that the other side can be compensated by cost, the question of filing the written statement under the Order 8, Rule 2 within 90 days does not arise. So, putting it straight, period of 90 days is not mandatory. Though the courts are insisting, saying that the written statement is to be filed within 90 days, unless the court is a commercial court, it is absolutely not mandatory. It's only obligatory. When the other side could be compensated by cost, the period of 90 days need not be adhered to. That is Order 8, Rule 2. Then we come to Order 8, Rule 2, Order 8, Rule 3. That speaks about filing of documents by the defendant or defendants after the written statement, or along with the written statement, or even after the written statement, by explaining the delay, why it was not filed earlier. That is Order 8, Rule 3. Earlier, we had a provision under the old code, Order 13, Rule 2, which provides for delay in filing documents by the defendant or the plaintiff, as the case may be. Now, Order 13, Rule 2 does not apply for filing documents either by the plaintiff or by the defendant. Then we go to Order 8, Rule 6, which speaks about filing of counterclaim. I'm sorry, filing of counterclaim. When I'll let you know what is meant by set off and counterclaim. Set off means where a suit is filed for recovery of, let us say, 10 lakhs. And plaintiff files a suit against the defendant for 10 lakhs. And the same transaction, the plaintiff is due 6 lakhs to the defendant. And the relationship between the parties is almost similar. That is, they are the adversaries. Instead of the defendant filing a separate suit and asking for adjustment in the same suit, the defendant can ask for adjustment, saying, "Sir, a suit is no doubt filed for 10 lakhs, but I have to get 6 lakhs from the plaintiff in respect of the same transaction." Then that 6 lakhs can be deducted or can be adjusted, and the plaintiff's claim will be restricted only to the extent of 4 lakhs. This is what is called set off or adjustment between the parties. Then we go to next aspect is counterclaim. What do you mean by counterclaim? Counterclaim means, suppose let us say a suit is filed for eviction and the landlord has promised to extend the lease and execute a fresh lease deed in favor of the lessee or in favor of the tenant. Then that is a binding agreement which is subsisting between the parties. Then instead of filing a separate suit for specific performance to direct the plaintiff to execute the document, then the defendant can in the same suit raise a counterclaim and say, "Sir, on particular day, the plaintiff promised to execute and register a fresh lease deed for a fresh period. And please compel the plaintiff to execute and register the sale deed for a further period that is agreed upon." And one thing you must remember is, in set-off, you need not pay any court fee. But as far as counterclaim is concerned, it is in the nature of a cross suit. Instead of the defendant filing a suit for specific performance, in the same suit filed by the plaintiff, he can ask for a counterclaim to compel the plaintiff to execute and register the sale deed. One important thing you must remember is, when you raise a counterclaim, you will have to pay the necessary court fee as far as the excess amount is concerned. Instead of going for a separate suit, in the same suit, the claim can be settled. Instead of going for multiplicity of suits, the court can decide the matter on the main claim as well as on the counterclaim that is raised by the party. One important thing in this Order 8 Rule 6 is, you've got a provision called Order 8 Rule 6A, which says when you raise a counterclaim in the written statement, the other side has got a right of filing an additional written statement. But here you must remember, unless you give notice to the plaintiff that you have raised a counterclaim also in the written statement, in the procedure, and if the court allows the counterclaim, please remember it is illegal. So notice is absolutely mandatory to the opposite side, and for the court to order the counterclaim, court has to hear both sides and then decide the matter. Then one more question arises, "Sir, if the plaint is dismissed for any reason, let us say, then in that case, is it necessary that the counterclaim also has to be dismissed?" No, counterclaim can be decreed irrespective of the fact that the suit has been dismissed. So counterclaim survives even after the dismissal of the suit, and counterclaim can be like a cross suit, which is normally filed by the defendant, but in the same suit, a finding can be given on the main claim as well as the counterclaim. Then the question arises, "Sir, should the counterclaim be proved and established?" Yes, definitely so. When the plaintiff tries to prove and establish his claim, you also as a defendant, when you have raised a counterclaim, it is incumbent upon you to prove and establish the counterclaim which you have raised. But counterclaim can arise only when it arises out of the same transaction. But if it is some other transaction which is unconnected with the suit claim, such counterclaim will not be entertained by the court. Then we go to Order 8, Rule 9. That is what is called alternate pleadings. What do you mean by alternate pleadings? Alternate pleadings mean, this is normally called in short as a rejoinder which you file. Alternate pleadings is, suppose let us say the plaint is filed into the court, the defendant appears and files a written statement, and there are some contradictions, there are some inconsistencies in the plaint filed by the plaintiff. Then in that case, you can always file what is called alternate pleadings, amend your plaint or amend your written statement or so. So, what is called is alternate pleadings or additional pleadings, as they may call it, is called a rejoinder. Only the plaintiff has got a right of filing it, subject to the approval or sanction, or the court has to grant leave to file a rejoinder. So a petition has to be filed under Order 8, Rule 9, asking for permission to file rejoinder, and along with that, you must file the rejoinder. Please remember, there the matter ends. The defendant will not be given an opportunity of filing an additional written statement in respect of the rejoinder. First is the plaint, next is a written statement, and third one is what is called additional pleadings. If the plaintiff has the only right to file the rejoinder, and that too with the permission of the court, a petition for permission, or what is called an interlocutory application, has to be filed for permission to file rejoinder. It cannot be allowed as a matter of right, and normally rejoinder is filed to explain certain contradictions in the written statement and try to explain it further and elucidate the matter further, so that your written statement of the defense which you have raised is absolutely clear and unequivocal. That is what Order 8, Rule 9 speaks about. This is as far as the written statement is, Order 8 is concerned. That is the point regarding written statement. Then we have what is called Order 9. Order 9, appearance of parties and consequences of non-appearance. Appearance of parties mean on the day when the date is fixed for the hearing, it is incumbent upon the defendant to be present in person or through an advocate or through an agent. And if he is not present on that particular day at that particular time before that said court, the court has got the power to set the defendant ex parte and then proceed with the matter. Please don't be under the impression that if the defendant is set ex parte, the suit is automatically decreed. No. Plaintiff has to establish and prove before the court the veracity, genuineness of the claim. Unless he satisfies the court regarding the genuineness and veracity of the averments that are made in the plaint, he cannot succeed. Then, sir, if the defendant does not appear, what are the consequences? The consequences are the defendant will be set ex parte and matter will be proceeded. Plaintiff will be asked to give evidence regarding his claim. Sir, I put it the other way around. Suppose the plaintiff is absent on the date that is fixed for hearing. What are the consequences? The suit will be dismissed for default, for non-prosecution rather. I put it that way. That is, but there is a remedy for the defendant to set aside the ex parte decree. That is, you file a petition under Order 9, Rule 7. Order 9, Rule 7 is a petition which you file, that is an IA which you file, a petition accompanied by an affidavit to set aside the ex parte order that is passed on that particular day. What are the requisites of filing this petition? One is you must show sufficient cause why you are absent on that particular day, what prevented you from attending the court, and what are the reasons why you want the ex parte order to be set aside. Then if the court is satisfied that you have shown sufficient cause, then the court sets aside or cancels the ex parte order that has been passed. And please remember one thing, that there is no limitation for filing a petition for setting aside the ex parte order under Order 9, Rule 7. This you bear it in mind. Then we go into the other aspect. Suppose the plaintiff is absent on that particular day when it is posted for hearing or otherwise, then in that case the suit is dismissed for default. Then in that case, as an advocate for the plaintiff, you have to file an application for restoration of the suit under Order 9, Rule 9. Show sufficient cause why you were absent on that particular day when it was posted for hearing, and then if the court is satisfied that sufficient cause has been shown, then in that case the court can restore the suit on the file and take it on the file and then proceed with the hearing. Here also, as far as Order 9, Rule 9 is concerned, there is no limitation, please. There is no period fixed within which you must file a petition for restoration of the suit. Then we go to Order 9, Rule 4. Mostly, suppose the summons are not served on the defendant. Let us say it is affixed or the door is locked or the defendant is not found. The court orders fresh summons to be sent through court or by registered post. Then in that particular case, you will have, suppose the court orders for fresh summons, you don't deposit the process within 3 days period, the court dismisses the claim as far as that defendant is concerned for non-prosecution because you have not paid the bata or you have not paid the process. Then in that particular case, you can always file a petition under Order 9, Rule 4, asking for restoration, for setting aside the dismissal order for non-payment of process. Then, suppose there is a delay in filing that petition, then you resort to 148 or 149 Civil Procedure Code. Within 30 days, you can file an application to restore the suit. But normally speaking, for when the suit is dismissed for non-prosecution, there is no limitation at all. That is Order 9, Rule 14. Then we come to a very important aspect as far as Order 9 is concerned. That is Order 9, Rule 13. Order 9, Rule 13 says, when the defendant has been set ex parte and let us say the plaintiff has been examined, the court is satisfied about the genuineness of the claim based on facts and documents, then the court decrees the suit. Decrease the suit is, it holds it in favor of the plaintiff. Then the question arises, so what the defendant should do? Defendant must file an application under Order 9, Rule 13 to set aside the ex parte decree. Here the limitation period is mentioned. Within 30 days, the petition has to be filed. What is called an interlocutory application has to be filed to set aside the ex parte decree. And sufficient cause has to be shown as to why you are absent, why you are not present before the court, and why the decree was passed against you. Then in that particular case, if you show sufficient cause, the court can set aside the ex parte decree. So sometimes it so happens fraud is played by the plaintiff. Please remember, everyone has got a price. You work up with the process server, get a false endorsement of refused, and the party has not refused it. The process server has not gone to the spot, but it has been managed. Then you say, sir, process server has not come to my place. I have never refused to receive the summons. No summons were served on me, but that is the reason, sir, I am filing this petition to set aside the ex parte decree. Then in all appropriate cases, when the court finds wrong address has been given, wrong endorsement of refused has been mentioned, and the process server has given a false report, then in that case, the court can, irrespective of the 30 days period that is mentioned in Order 9, Rule 13, the court can accept the application and set aside the ex parte decree. But please remember, it is not a blanket order which is passed by the court. Suppose it is a suit for money, then you will be asked to deposit 50% of the amount into the court to the satisfaction of the decree. And or, in other words, you will be asked to pay cost to the opposite side or deposit the money before the legal service authority towards the cost that is imposed. Then we go to what is called discovery, inspection, and production of documents. That is Order 10, Order 11, and Order 12. What do you mean by that? Discovery. Suppose, let us say, the document which forms the basis or the crux of the case is in the custody of the opposite side. Then you can ask the court to file an application under the provisions of Order 10, asking the court to direct the opposite party to produce the documents into court. Then once the documents are produced into court, the defendant or the party who calls upon it can also inspect the documents in the presence of the court or in the presence of the sheriff sadar or in the presence of the superintendent. Then production of documents. Sometimes what happens is the documents are in the custody of the opposite side. Then you can ask the other side by giving a notice, sir, these are the documents, that is the advocate is on record, give a notice to him, please direct your client to produce the following documents into the court. Then once notice is given, the party is bound to file those documents. That is Order 11, Rule 14. Suppose, let us say, the party does not produce the documents, then you can file an application before the court, sir. I've already given a notice to the other opposite side through his advocate to produce the document, but he has not done so. This is the notice which I have given him. And in spite of that, he has not produced the document. Then in that case, the court can direct the opposite party to produce the document into court. Suppose the documents are not produced into the court, then the court can draw adverse inference by saying if the documents are filed, it would go against him. That is the reason why the documents are not filed. Then in order 11, we have also got a provision called interrogatories. What do you mean by interrogatories? Sometimes it may so happen you cannot procure the presence of the party, presence of the witness. And in that case, what happens is you prepare a questionnaire and ask the party to answer either in the affirmative or in the negative. They are called interrogatories. And sometimes I think, a lot of scams are taking place where the person who is the culprit runs away from the jurisdiction of the court, goes to a foreign country and seeks asylum there. Then you can administer interrogatories on that person, ask him to answer either in the affirmative or in the negative, and the interrogatories forms part and parcel of the record of the court. That is what interrogatories mean. Of course, in our country, we don't have this in regular practice. But mostly what happens is when you are trying to examine higher officials, it is preferable to administer interrogatories so that much of the time of the court can be saved. Then we go to the provisions called Order 13. Order 13, here we say there are very, very small sections, small rules, where Order 13, Rule 2 says, if the plaintiff wants to file documents after the suit has been numbered and the process, summons have been served on the opposite side, he files it under Order 13, Rule 2. It is either the plaintiff or the defendant. But now Order 13, Rule 2, after the amendment of CPC, does not apply as far as civil proceedings are concerned. I told you in the earlier lecture and even today that if the plaintiff wants to file it, he must file it under Order 7, Rule 14, bracket 2. And if the defendant wants to file it, he must file it under Order 8, Rule 3. Then we go to return of what is called return of exhibited documents. That is the documents which are produced into court and marked as exhibits, and you want return of that document, you can always file a petition before the court under order 13, asking the court to return the exhibited documents. But one condition is you must try to substitute it with certified copies and give an undertaking before the court. Sir, as and when required, I undertake to produce the original documents into court. Please return it immediately. I require it for some other purpose. Then the court, for reasons recorded, once the certified copies are obtained and substituted, the court returns the original documents. But what is the procedure regarding return of unexhibited documents, documents which have been rejected, documents which have not been marked? In that case, the court need not insist on formalities, but can return it even without any opposition from the opposite side. Then sometimes what happens is we may have to summon some records from a court or from a public authority. Then you have got the provisions called Order 13, Rule 9 and Order 13, Rule 10, which says you can always summon the records from the court, from another court or the same court, and also give a list of them, what you want, and then also pay the bata, the process, and also the necessary forms under the rules of civil rules of practice, whether it is 22 or 23, form 22 or 23. If it is from the same court, it is form number 22 of the civil rules of practice. If it is from the other court or a public authority, it is form 23. And you have to file it in duplicate and mention what are the documents you want from that particular court. And here also the procedure is, once the documents come to the court, in pursuant to the summons which are issued, you have to mark those documents and then substitute it with certified copies, and then the originals go back to the authority which has sent those documents. Then this is as far as Order 13 is concerned. Then we go into another important aspect, other stage of the suit, that is called Order 14. Order 14 speaks about issues. What do you mean by issues? Suppose you are having a meeting. For the meeting, you have the agenda. Agenda says these are the points which are going to be discussed, raised in the meeting. In the same way, as far as a civil suit is concerned, the court is called upon to frame issues. Issues means points on which the parties are at variance, they are differing. How the points of variance is determined? Looking into the plain, looking into the written statement, points are framed. Whether the plaintiff is entitled for perpetual injunction as paid for, whether the plaintiff is entitled for removal of the structures by a decree for mandatory injunction, whether the plaintiff is entitled for what is called damages as claimed. And next one is whether the defendant is entitled for the counterclaim that has been raised in the written statement, so on and so forth. These are the points where the parties are differing and which has to be decided by the court. If you take the case of a property dispute, a partition suit that has been filed, then in that particular case, the court has to determine whether the suit scheduled property which is claimed by way of partition is an ancestral property or is a self-acquired property. If it's an ancestral property, what is the share of the plaintiff? What is the share of the defendant? If it's a self-acquired property, what is the share of the plaintiff? What is the share of the defendant? Fourth one is whether the plaintiff was justified, whether the defendant was justified in alienating the share of the defendant. Then whether the suit is barred by limitation to what relief. These are the points which have to be discussed as far as points where the court is asked to decide, and issues are framed based on the points raised in the plain and the points raised in the written statement. It's something like a questionnaire which is prepared, which helps the court to determine the matters involved in the controversy. Then let us say in one case the court finds that additional issues have to be framed, and the court says parties know their case, parties are well aware of their status, I need not frame the issues. Please remember, in this particular case, suppose the court feels that additional issues have to be framed and the court does not do it, it abdicates its duty, and the appellate court or the higher court can always remand the matter back to the lower court to frame the issues and decide the case accordingly. So the court is not a charity as far as framing issues are concerned. That is the reason it is said that the issues have to be framed after hearing both the parties. But unfortunately, what happens is neither the plaintiff is present nor the defendant is present to advance arguments regarding framing of issues. So the court itself takes upon the headache upon itself and frames certain issues. But here, one important thing you must remember is sometimes what happens is the issues are wrongly framed. Instead of one issue, one question, the court frames it in a different way. Then in that case, you must also ask for alteration, reframing of issues, or recasting of issues. Then in that particular case, if the court finds that the recasting has to be done, the court can always do it. Next one is, one amendment has come, that is Order 14, Rule 5, which says, if scandalous, vexatious, and troublesome averments are raised, the court can order for striking out those scandalous points and vexatious points, and that is what Order 14, Rule 5 is concerned. And that has come by way of a special amendment by the amended code of 2002. Then we go to Order 16, which says summoning of witnesses for giving oral evidence and for production of documents. Order 16 is a procedure which says, suppose, let us say, after all, once the issues are framed by the court, it is incumbent upon the plaintiff or the defendant to file into the court list of witnesses and documents. Suppose they don't file the list of witnesses and documents and they are not mentioned, the court can order for summons for production of witness. Then in that case, summons are issued to that particular witness to give evidence. That is giving oral evidence. But suppose the records are there with a particular authority, you can ask the court to issue summons to the particular office or particular bank or a particular institution to produce the documents and to give evidence on those documents. But one thing you must remember is, suppose you summon a witness to give oral evidence, or suppose you summon an institution to produce documents, you have to deposit what is called bata. Bata means the traveling expenses of the witness to attend the court on a particular day at a particular time, either to give oral evidence or to produce documents. Here also one thing you must remember is, once the authority or that particular person produces the document, you cannot allow the documents to remain in the court. you must substitute it with certified copies and the witness takes back the original documents. Why? Because the original documents are required by the institution or the bank or anyone for daily use. Then we go to a particular provision in which a junior advocate should specialize: adjournments. Now, court delays are there. Why? Because advocates seek adjournment on every date of hearing. Please remember here, adjournment means suppose a court is listed for, the case is listed for giving evidence. On that particular day, you are not able to produce a witness. You file an adjournment petition before the court and give reasons why you cannot proceed with the trial and why you want the case to be adjourned. But normally the rule is you cannot seek adjournments on every date of hearing. Nowadays, we have got the hit list issued by the High Court to say there are some matters are old matters which come under the head of identified cases. In that case, mostly court grants you only 3 adjournments, and beyond that, if you try to ask adjournment, the court grant cause or court may refuse to adjourn the matter. Then you got one provision in Order 17. Suppose a conditional order is passed that you must go on with the trial. On that particular day, your witness is absent, you cannot procure the attendance of the witness, and you are not able to comply with the conditional order that has been passed by the court. Then in that particular case, you file a petition under Order 17, Rule 3 to relax the conditional order and grant an adjournment. The much emphasis need not be given as far as Order 17 is concerned. But Order 18 is a very important provision which we have to remember. Order 18 speaks about, I think some of you who have been practicing on the criminal side know that one may be good in only talking, or one may be good in writing. You need not necessarily be good in talking. One is a good orator and he is not a good writer. He may be a good writer, but he is not an orator. What happens? Because please remember, all of us are not fortunate to come from English mediums. We come from vernaculars also. We come from Telugu medium, we come from Hindi medium, we come from Kannada, Tamil, or whatever it is. Then in that particular case, what happens is we may not be able to speak eloquently in the language that is English. After all, please remember one thing: English is not our language. English is a foreign language, but our language is the mother tongue or the vernacular which we speak at home. Here, as far as Hyderabad is concerned, or Hyderabad, let us say Telangana or Andhra is concerned, the language which is spoken is mostly Telugu. Please remember, if you are fluent in Telugu, don't feel shy of arguing in Telugu. Argue in Telugu, the court is bound to listen to you. But if you are not thorough with the English, you can speak in Telugu. But if you are not thorough with Telugu, you can speak in English. Absolutely, there is no bar. But don't speak in vernacular English, as they call it. What do you mean by vernacular English? Vernacular English means you formulate a particular point in your mind in Telugu. You literally translate it into English and then try to speak out. Please remember, it looks absurd. Here, I could give you one humorous incident which happened in a civil court. The judge was a Muslim. Please remember, mostly Muslims and Rajputs use the word, they don't use the word tum. They will say up, hum. Hum means we. It's literally, if you translate it into English, it is we. What happened was that particular judge said, we hereby hold that so-and-so. Then the matter came up before the High Court judge, and he was curious to know as to whether there is a division bench in the lower court. Please remember, one of the advocates got up and said, sir, the word hum means not we, but it is I, because it's giving respect to that particular thing, that is particular person himself. So please remember, sometimes avoid speaking in a language which you are not thorough with. That is, suppose you are not fluent in Telugu, English, speak in Telugu. There's no bar. No one will make fun of you, and people will feel proud if you argue in Telugu because it's your regional language. You are thorough with Tamil, speak in Tamil. Perhaps if the judge knows it, some other person has to translate it. Suppose you know Malayalam only, not any other language, speak in Malayalam. You must try to get out of an advocate who knows Malayalam, who can translate that into the court. So here Order 18 speaks about why I'm trying to tell you that is, In CRPC, you got a provision called 314. 314, that is filing of written arguments. As far as a criminal case is concerned, you have conducted it, but you are not able to express it because you lack expression power. Then in that case, you put whatever you want to submit before the court in writing and file it in the court in the form of what is called written arguments. And please remember, one advantage of filing written arguments before the court is the court cannot bypass the points which you have urged, points which you have raised, points which you have pointed out, inconsistencies which you have pointed out, contradictions which you have pointed out, and what is the evidence of a particular person, how it has to be appreciated, what is the case law on that particular aspect, how the particular court decided that matter in a particular way. And once you file written arguments to the court, whether the judge likes it or not, he has to look into your written arguments and pass a judgment. Straight away, he cannot pass a judgment based on his own understanding. That is the advantage of filing written arguments. So by the amendment in 2002, they felt that people are lacking as far as expression power is concerned. They lack in oratory. So a provision has to be provided whereby a party can be permitted to file written arguments before the court. That is Order 18, Rule 2, bracket 3. That once the trial is completed, evidences are recorded, then in that particular arguments are also heard by the court, then the party within 7 days, once the arguments are over, he has got a right of filing into the court a document called written arguments. Once the plaintiff files the written arguments, the defendant also has got a further period of 7 days within which he can prepare written arguments along with the case law and file it into the court. This enables the court to cut down much of the court's time. Why? Because sometimes what happens is, gone are those days when people argue for 6 days, 10 days, 15 days, or even for 1 month. Now the court can say, look, mister, I'm giving you 30 minutes time or 1 hour time, finish your argument by that time. And if you're so interested, file your written arguments. Now the provision has been provided, Order 18, Rule 2, bracket 3, where it says you can file written arguments into the court. And once you file written arguments into the court, let us say, God forbidden, you lose the case. Then when you file an appeal before the appellate court, you can say, sir, these are the points which are mentioned in the written arguments. The court has bypassed these points and court has not adverted on these points. Please try to look into it. It always gives you a weapon in your hand to attack the lower court. To say lower court has not adverted properly, not decided the matter properly. That is why it is said that the appellate court is like a mother-in-law and the lower court is like a daughter-in-law. I think you know, Atta Kodala Kayal Meek Telsu. The question is, the mother-in-law feels, because she has suffered in the hands of her mother-in-law, she feels that whatever the daughter-in-law has done, or Kodal is chesinanta tappu, aame cheppinadi correct. Then she says, Kodala, nu chesinది tappu, nu chesinది tappu sarididukoni. There starts the confrontation between the mother-in-law and the daughter-in-law. నువ్వు నన్ను చెప్తావా అని చెప్పి ఆ కోడలు ఎదురు భర్తకు చెప్తున్నాను, భర్త పోయి తల్లికి చెప్తాడు, నా భార్య, వాడి తల్లి అనేది మర్చిపోతాడు, నా భార్యని అన్నావా అని చెప్పి వీడికి కయ్యం పెట్టుకుంటాడు. అందుకే అంటారు, తెలుగులో సినిమా కూడా వచ్చింది, తల్లా పెండ్లామా అని. నైదర్ యూ కెన్ టాక్ in favor of the daughter, in favor of your wife, or in favor of your mother. So here it is said, that's why it is said, appellate court, whenever the lower court commits a mistake on a particular point, a wrong appreciation of evidence, a wrong appreciation of the case law that has been cited, it corrects it in its judgment. That is why it is said the appellate court is like a mother-in-law and the lower court is like a daughter-in-law. Don't translate it to real practice, which is only in a humorous way. Then the advantage of filing written arguments before the court is, the court, please remember, don't trust your memory. Memory fails you at the appropriate time. We are not so great to have everything in our mind, because our mind is not a dustbin where you can store everything. Sometimes what happens is, dustbin also has to be cleared every day. Here also, every case has to be cleared on a particular day. And once the dirt accumulates in your brain, please remember, your brain becomes rotten. In that way, that is why when you file written arguments, you can always say, sir, I've raised these points. These points have not been gone into by the lower court. And the appellate court can always correct it by giving its own version. Then we go to the amended provision. New provision has been introduced, Order 18, Rule 4 and Rule 5, which says all evidences in chief, please underline that word, all evidences in chief shall, not may, shall be filed by an affidavit. Please remember, I was the first person to criticize the amendment by saying the originality of a person is gone. Please remember, once a person appears before in the court, in the witness box, his demeanor is something different. But once he is asked to file only the form of an affidavit, what happens is every trash is introduced there. Please remember, we advocates, I'm sorry, including me, we advocates go to the typist and say, Are Babu, evidence ID is action the evidence affidavit kotra Babu antam. వాడు ఏం చేస్తాడో right from jurisdiction, cause of action, prayer, everything is incorporated. Chatta, chataram, anta add చేస్తాడు. That is not the evidence. What you would have stated had you appeared in the court in person. In short, the sum and substance of the plea, sum and substance of the pleadings which you have raised, that is supposed to be the evidence. Pleadings cannot be a substitute for evidence. Evidence is something different. Pleading is something different. But evidence is in consonance with the pleadings which you have raised. In a concise form, you try to shorten it. And what you would have deposed before the court, that is called an evidence affidavit. That is the reason why Order 18 Rule 4 says all evidences in chief will have to be, shall be filed by way of an affidavit. And along with that, whatever documents you want to get it marked, you mention the list and ask the court to mark it. Please remember, the court has got the right, a court has got the absolute power to mark the document subject to admissibility, relevancy, so on and so forth. It marks it as an exhibits. That is, once it's marked as exhibits, on the plaintiff side, it's marked as A series, and on the side of the defendant, it's marked as B series. Then the court may itself record the cross-examination or refer the matter or delegate the matter to an advocate commissioner to record the cross-examination and to file the report into the court. And mostly, this is helping most of the junior advocates who are appointed as commissioners who record the cross-examination. But the seriousness which you have in court while giving evidence is lost once you cross-examine before the commissioner. Please remember, all of us have got some vices. Some of us are used to smoking. Some of us are used to chewing pan, so on and so forth. That you tell the commissioner, unko 15 నిమిషాలు ఉండమా ఇప్పుడు వస్తాను, అంతలోపు సిగరెట్ తాగేసి వస్తాను అనమాట. So like that, or let us say I'm not free today, you post it on some other day. If one person agrees, the other person does not agree. Like that, matters are prolonged for months together. So sometimes, and please remember, the junior advocates who are appointed to record the evidence are not that equipped like a court to record the evidence. And sometimes disputes arise. Please remember, shouting takes place before a commissioner. You introduce a particular fact that is either accepted by the party or rejected by the party. You lose your temper. The other side loses the temper. The seriousness is lost. The matter is adjourned. But in a court, it is not like that. In a court, once the cross-examination is done, seriousness is there, demeanor is noted, the witness is also scared while giving evidence. So all seriousness is lost when advocates are appointed as commissioners. I am not against that, please, because it helps most of the juniors to make money in the initial stages. Then, of course, I could tell you one more unhealthy practice has come. You see at 2:30 in the court hall, you will find all the junior advocates assembled there. Yemama, nu chestava cross-examination record chesta sir. Then you are appointed as commissioner. 1,500 or 2,000 or 2,500 is fixed as your commission fees, where you can record the cross-examination. Well, what happens is, we seniors, of course, I am not boasting of myself, find it difficult to find juniors. Why? Because now finding servant mates is very difficult, especially when you have independent houses. But when you have flats, you get servant mates, because nowadays construction activity is going on. They get much more in construction activity rather than what you pay as their salary by every month. So here also what happens is, most of the juniors are meereemiches are నాకు 10 commissions వస్తూ సార్ నాకు నెల నడిచిపోతుంది. So the question is, and these junior advocates are only, they carry a pad, they carry papers, they attend the court exactly at 2:30 when the court they just look at the court for whether the judge is looking at her or not, her or him, whatever it is. Sir, are you prepared? Yes, sir, I'm prepared to do it. Then you are appointed as commissioner. Then what happens is your study of the subject goes. You are not bothered about conducting a case. You are not bothered about guiding your senior. You are not bothered about helping your senior. So many problems are there. Of course, Order 18, Rule 4 and 5, no doubt it is there to shorten the time of the court, but it is counterproductive also. Then we go to the provisions of Order 19, which speaks about affidavits. Here, only one or two things have to be noted here. That is, affidavits. What do you mean by an affidavit? Affidavit is supposed to be a sworn statement of facts sworn to by a person on oath. That is, when you try to take oath in the name of God or in the name of Bhagavad Gita and say whatever I'm speaking is truth and nothing but truth. That is called an affidavit. An affidavit is nothing but a statement made in the first person, stating few facts. But sometimes what happens is when affidavits are filed into the court, wrong statements are mentioned. There is distortion of facts, distortion of material facts which have to be mentioned. Then in that case, Order 19, Rule 2 says you can always file an application or an interlocutory application to cross-examine the deponent who has given. The deponent is a person who deposes to the facts by way of an affidavit, is called a deponent, and then the court grants you permission to cross-examine him. Then please, one distinction you have to make here. As far as a Hindu is concerned, a Hindu takes oath. But as far as a Muslim is concerned, it is against the Shariat that a Muslim never swears. He only says, I affirm and state as follows. He doesn't say, he doesn't say state as follows on oath. He only says affirm and state as follows. And a Muslim who gives an affidavit is called an affirmant. AFFIRMANT. A Hindu or any other person who files an affidavit is called the deponent. A person who deposes to the facts in the first person is called the deponent. A person who affirms to certain facts when he is a Muslim, it is called an affirmation, or is called the person who gives that is called the affirmant. And we say sworn and signed before me on this so and so date before me advocate. But a Muslim says affirmed and state affirmed and signed before the advocate on so and so date. Please remember, a Muslim doesn't take oath. This is a precaution which you have to take. Oath is against the Muslim law. So they only affirm to the facts that are mentioned in the affidavit. Then we go into the important provision, which is the finale as far as the suit is concerned, as far as the judge is concerned. That is Order 20. Here, Order 20 speaks about judgment and decree. మన తెలుగులో తీర్మానం అంటాం, లేకపోతే తీర్పు అంటాం, లేకపోతే ఫైసలా అంటాం ఈ ఉర్దూలో. Here, based on the facts mentioned in the pleadings, based on the facts and based on the documents, the court and the case law which has been cited by both the parties, the court proceeds to pass a judgment as far as that particular suit is concerned. Please remember, judgment is a word which is spelled in two ways: JUDGEMENT or JUDGMENT. What do you mean by that? If you divide that word, judgment, pronouncement made by a judicial officer during the course of his office, is what is called a judgment. Tirpu, tirmanam, lepote, faisala, it is called a judgment. That is a pronouncement made by a judicial officer vis-a-vis the facts of the case, vis-a-vis the evidence that is on record, the contradictions which are on record, the inconsistencies which are on record, or the case or case law which is on record, or the issues that have been framed. What are the findings of that particular judge as far as those issues or points are concerned? This is what is called judgment. Then judgment, how it has to be prepared? Judgment has to be prepared by first saying that the brief facts of the case are so. This suit coming up before me on this is a day of so and so, before so and so advocate for the plaintiff and so advocate for the defendant. The court doth pass the judgment in the following manner. Then the judgment is there. The court first extracts the brief facts of the case, the written statement that has been filed by the opposite side, or the counterclaim that has been raised by the opposite side. The issues that are framed by the court is also extracted, And then on every issue that has been framed by the court discusses the pleadings, discusses the evidence, discusses the cross-examination, discusses the inconsistencies, discusses the contradictions, and the case law on that particular subject. And if it agrees with the plaintiff, it says issue number 1 is decided in favor of the plaintiff. Suppose, let us say, the court comes to the conclusion that the issue is not in favor of the plaintiff. The court says, I reject this issue is held in favor of the defendant. Then each issue, court has to decide, court has to give its own findings, and court will have to discuss the matter, look into the inconsistencies and the contradictions, and also the case law that has been cited in that particular manner. Ultimately, what the court has to do is, based on all the issues, the court comes to the following conclusion. That is, the suit of the plaintiff is hereby decreed with cause. What do you mean by decreed? That means the plaintiff has proved all the facts beyond any shadow of doubt, and the court has court is leaning more towards the plaintiff. And sometimes it so happens issue number 1, issue number 2 is decided in favor of the plaintiff. Issue number 3, 4, and 5, which are framed by the court, is held against the plaintiff. That is 2 in favor of the plaintiff, 3 in favor of the defendant. Then in that particular case, the court says, so as far as issue number 3, 4, and 5 are concerned, it is held against the plaintiff and it is decided in favor of the defendant. Then given under my hand and seal on this day of so-and-so, judge signs it, he puts his seal there, and then the judgment is prepared upon it. Is this clear to you, please? Then the question arises, within what time the judgment has to be passed? Please remember, except in the High Court perhaps, the judgment is not pronounced immediately. In the High Court, mostly writ petitions are decided on the same day itself. When already it is settled law, court dictates the judgment on the same day and is pronounced on the same day and decided accordingly. But if the High Court or the Superior Court feels that more complication is required, it reserves the judgment to be pronounced within 14 days. Reserves means it will pronounce it on that particular day. Then, but what happens is, please remember, though it is 14 days, the court does not pass the judgment within 14 days. It goes on extending it. And now, according to the new amended Code of Civil Procedure, it is said the court can pronounce the judgment within 30 days. Because of the quantum of work, the heavy work that is there in the court, the judge cannot avert his mind to pass a judgment. So within 30 days, the judgment can be passed at any time, but subject to notice being given to both the sides that the judgment will be pronounced in the open court on this particular day at a particular, they don't say the time, particular day. Then on that particular day, the court passes the judgment in the presence of both the advocates. But what the court is expected to do is, it must read the entire judgment. But please remember, courts do not have that time to read the entire judgment. Only the operative portion of it, they try to read and explain. But one thing is this, I still remember a humorous joke which happened in our civil court here in Hyderabad, where what happened was, a particular advocate was a senior advocate. Most of you know the Ittihadul Muslimin. There is the founder of Ittihadul Muslimin here was Abdul Wahid Owaisi. There is the father of Salahuddin Owaisi. What happened was, he attended that court on that particular day. A junior was asked to take the judgment by his senior. The junior appeared there and wanted, because the judgments are normally pronounced at 4 o'clock, and the court, the party also, you know, the Hyderabad courtesies, they'll be standing like this. Then the judge says, the suit of the plaintiff is hereby dismissed. Then the party was anxious to say, sir, Vakil Sahab, hamara muqaddama kya hua? Then the advocate said, sir, this suit has been held against us, our suit has been dismissed. Then this particular senior advocate, Mr. Owaisi, called the junior advocate aside and said, but he said in chaste Urdu, Barkurudar, aapke kitna tajruba hai? Or what is the experience you have in the profession? He said, sir, hardly 3 months. Your senior knows that this case is going to go against him, and that's why he has asked you to take the judgment. Don't tell your client that first try to prostrate before the client by giving his salami, and then say, sir, I'm thankful for you to write the judgment. But see, then this advocate said, sir, why should I prostrate before the court? He said, thank you very much, Mr. Judicial Officer. You have given me permission to file an appeal before the appellate court. Suppose the appellate court also go, then you tell your client, your case is so complicated, it requires to be decided by a bigger brain, that is appellate court, and he has given you permission to file an appeal. Suppose the appellate court also goes against me, sir, what should I do? Then he says, you prostrate before the appellate court and say, thank you very much, sir. You have permitted me to go to the High Court and see the High Court and argue the matter there. Suppose the High Court also holds it against me, sir, what should I do? Then you go to the Qutub Minar, that is Supreme Court, and argue your matter there. Suppose the Supreme Court also says, sir, your case is dismissed. What should I do? Then put both your hands up and say, Allah said, dua mang. That means you keep the client in a ray of hope and say, your suit is very, very complicated. It has to go to the highest court. Of course, I am not saying for a moment fool your client, but this is the real trick of the profession. You hang on to the client, or your client hangs on to you till the last minute, that there's some flicker of hope in the horizon. So here one thing is this. Here, as far as judgment is concerned, court has to go on all aspects. Please remember, I've seen most of the courts today write slipshod judgments where they do not go into every issue. They do not go into the pleadings. They do not go into the evidence. They do not go into the inconsistencies. They do not go into the contradictions. They do not appreciate the case law which you have cited before the court. They say what has gone wrong. They don't decide. Then in that particular case, always you've got a right of appeal. When you've got a right of appeal before the appellate court, even the appellate court, they follow the cut and paste principle. They copy the entire lower court judgment, and last they say strenuous arguments have been urged by the appellant and the respondent, but I find no reasons to annul the judgment of the lower court. The judgment and decree of the lower court is hereby confirmed. In very, very rare cases, the judgment and decree of the lower court is set aside. Except when the judge is conscientious, he goes into every aspect and then decides the matter. Then now with the earlier court, it said within 14 days the judgment has to be passed. Now within 30 days, the judgment can be passed, which will be passed in the open court by giving notice to both the sides and then also pasting a copy of the notice on the notice board. And the operative portion or the entire judgment has to be read over by the judge in the open court, or the operative portion can be read over and then explained to the party. And if the party is appearing in person, party should be made aware of his rights. If the judge has to say, sir, within 30 days you have got a right of filing an appeal before the appellate court. Please take the copies of the judgment and go to the appellate court. Then what do you mean by decree? Decree means, please remember, if you look into your civil procedure code, decree is not defined anywhere. Even your dictionary does not define a decree. Decree means it is defined as sum and substance of the judgment. That is the only meaning that is given. But here, I would give you an example to explain in an objective way what is meant by a decree. Suppose you go to a fruit juice dealer, order for a glass of juice. What the fruit dealer does is he crushes the juice and then takes the juice and then puts a filter and then filters the juice. The residue remain on top and the filtrate comes down. What you consume is only the filtrate. That is a clear solution. The residue is thrown out. That means the filtrate, the clear solution which comes down is what is called a decree. The residue is nothing. And please remember, in a civil court, a civil litigation, decree plays a very important part. Your client is not interested about the judgment. Your client is interested whether he can read the fruits of the litigation which he has initiated before the court. And what is executed in a civil court is a decree and not a judgment. What a judgment is important for you to know the findings as far as the case which you have filed before the court. But it does not help you to execute it. What is important is decree is what is executed in a civil court. Then within 7 days from the date of judgment, decree is prepared. And within that time, you are supposed to file what is called MC and FC. MC means memo of cost. What you have spent for the suit, what you have paid for the plaintiff, what you have paid for the wakalat, summons to the witnesses, process fees, then advocate's fee, advocate junior's fee, then notice charges, so on and so forth. That is called the cost of the plaintiff. Then the cost of the defendant. Then the total is made. Then it's also mentioned who should pay whose cost. What is the relief that for what amount the suit has been decreed? What is the interest and at what rate it has been granted? On what amount the interest has to be computed from the date of suit till the date of decree, 24% or 18%. From the date of decree till the date of realization, 6%. More than 6% the court doesn't grant. Now I think it is now 9% the court can grant. Then who should pay whose cost? That's also be mentioned. Given under my hand and seal on this day of so and so. The judge puts his signature and puts a seal and then gives it to you. So what becomes executable in a civil court is not a judgment, but it's a decree. Am I making myself clear to you, please? Then in some cases, 2 decrees are passed. I think some of your advocates know. Like as far as a money suit is concerned, a simple money suit, only 1 decree is passed. But as far as a suit for partition, suit for accounts, suits for what is called suits for accounts, then suits for partnership, all these things, then suits on based on mortgage, etc., etc. 2 decrees are passed. One is called a preliminary decree, and another is called a final decree. Suppose, let us say, you file a suit for partition. You claim 1/4 share in this suit schedule property. A schedule, B schedule, C schedule, D schedule, whatever it may be. Then the preliminary decree says you are entitled for 1/4 share in A schedule, B schedule, C schedule, and D schedule. Then it passes a decree accordingly. There it stops with the preliminary decree. Then suppose you want your shares to be demarcated, divided, and allotted to you, you file an application for appointment of commissioner to divide the properties. Then the commissioner goes to the spot and then measures the property. Nowadays, tipans are gone. I think mostly, tipans have gone. Previously, they used to measure agricultural land with chains. 2 ana, 4 ana, 8 ana, and now those days are gone. Now we go according to the village map and according to the Google map. And then once the commissioner files a report into the court, the parties will be given an opportunity of filing their objections to the commissioner report. Then the matter will be heard by the court, and then if the court finds there is no objection that cannot be sustained, then it confirms the preliminary decree. Does the matter end there? No. Suppose, let us say, you file an eviction. Suppose you file an eviction suit. You ask for mean profits. What do you mean by mean profits? Mean profits is you ask for damages and compensation. Then in that particular case, court grants you no doubt a decree for eviction and possession, but says as far as mean profits are concerned, it has to be determined by a separate trial in the same suit. This provision is Order 20, Rule 18. I shall continue further as far as various aspects are concerned on this particular Order 20. Thank you very much. Any questions, please, by way of interaction? Yes. Yes. Please speak out. Unmute.
Good evening, sir.
Just a minute.
Who is this?
Hello.
Yes, please give out your name.
Sir, I am Chakravarti from Bhimavaram, sir.
Yes, sir. Tell me, sir.
సార్ నా ఇప్పుడు ప్రజెంట్ ఆర్డర్ 9 రూల్ 7 పిటిషన్ పెడుతున్నాం కదండి.
అవునండి.
పార్టీ ఆర్డర్ పాస్ చేసినప్పుడు ప్రెజెంట్ కోర్స్ ఏంటంటే 4 ఫీట్ ఆర్డర్ పాస్ చేస్తుంది.
Pardon?
4 ఫీట్ ఆర్డర్ 4 ఫీట్ రైట్ ఆఫ్ ఫైలింగ్ ఆఫ్ రిటర్న్ స్టేట్మెంట్ పాస్ చేస్తుంది.
Yes, sir. Yes, sir.
దానికి సంబంధించి ఏదైనా ప్రిస్క్రైబ్ లిమిటేషన్ ఏమైనా ఉందండి?
దానికి లిమిటేషన్ ఏమి లేదు సార్. దట్స్ వాట్ ది 2004 and 2005 Supreme Court has said. Except in a commercial court, the filing of written statement within 90 days in a lower court is only obligatory and not mandatory. There is no limitation for Order 9, Rule 7, but court insists you to file the written statement along with the application.
Thank you.
Right. Yes, next, please. Yes, next question, please.
Any more questions, or shall we conclude the Vivo?
Yes, sir.
Yes, please.
Sir,
What's your name?
Sir, Sam, sir. My name is Sam.
From?
Sir, I'm from Pune, sir.
Yeah. Please go on. Go ahead.
Sir, I just wanted to know what is the limitation period to claim the property from a joint property title?
As far as joint property title is concerned, there is no limitation. But if you want to recover immovable property, it is 12 years. And movable property, it is 3 years.
Okay, sir.
Am I clear, please?
In that case, sir, will the other party is in adverse position? Can he claim on adverse position?
Adverse possession should be 12 years of continuous period, uninterrupted, continuous, and without any obstruction from anyone. That is 12 years period.
Okay, 12 years. This is applicable for, is it applicable for joint property as well, sir? Relatives?
As far as joint properties is concerned, doesn't apply, sir.
Okay.
Next, please.
Sir, I am having a doubt regarding Section 44 of Transfer of Property Act.
Sir, I am not on Transfer of Property Act, sir. When I come to that, you kindly ask me that. That is feeding the grant by estoppel. 43 and 44 of TP Act. Yes.
Any more questions?
Sir, I am Gausi, advocate from Madanapalli, sir.
Yes.
Sir, do we have to file return statement in 90 days or 120 days, sir?
Not 120 days. 120 days is not there anywhere. But if you go through Order 8, Rule 2, it says 30 days. That is Order 8, Rule 1 is 30 days. But court can extend from time to time to the maximum period of 90 days. But as per the judgments of the Supreme Court in 2004 and 2005, it says filing of written statement within 90 days is only obligatory and not mandatory except when it is in a commercial court. Am I making myself clear to you, please, madam?
Yes, sir. Yes, sir.
Right.
Mr.
So,
Sridhar.
in commercial courts, we can file within 120 days. It can be extended up to 120 days, sir.
Provided you file an application. But beyond 90 days, a commercial court cannot extend.
Sir.
Yes.
In normal courts, we can extend up to 90 days only, sir.
Only 90 days. And commercial courts, I'm sorry, commercial courts. Other courts, you can file it even after 90 days, but court can compensate the other side by costs.
Mr. Sridhar.
So may I ask a question?
1 second, Santosh Garu. Please be on hold. Santosh Garu, please. Srinivas Garu, Sridhar Garu, please go ahead. Sridhar Garu, please unmute your mic. All right, Santosh Garu, go ahead.
Sir, I want to ask a question regarding counter claim.
Yes.
Whether the counter claim can be separately filed or it can
No,
be
it has counter claim cannot be separately filed in the written statement itself. It should be separately claimed provided it is within the period of limitation.
Okay.
When you file the written statement, along with the written statement, the counter claim should be also included in that.
Only,
you cannot file it separately. You cannot file it separately.
Okay. Thank you, sir.
You're welcome.
You.
Sir, I am Sridhar.
Yes, sir.
Sir, before the judgment, can we file that petition?
Which petition?
Sir.
Which petition, sir?
Sir, actually, it is the expert judgment.
Yes.
Before the judgment, I have filed my submission in the arguments also.
Yeah.
But other side party, they arrived the court and filed the satisfied petition.
Yes.
Is it admissible?
Even before the judgment is passed, at any time it can be filed, sir. There is no limitation for that, except in the case of an ex parte decree.
Ex parte decree only.
Ex parte decree 30 days. Within 30 days, it has to be filed. Order 9, Rule 13.
What Order 7 rules?
Not Order 7, Order 9, Rule 13.
Thank you, sir.
You're welcome.
Anybody else? Yes, Swami, sir. Please go ahead.
Yes.
Sir, good evening.
Good evening.
Sir, ఒక క్వశ్చన్ సార్. ముగ్గురు బ్రదర్స్ ఉన్నారు. ఫాదర్ మదర్ డైడ్ అయిపోయారు.
Right.
వాళ్ళ ఫాదర్ పైన మదర్ పైన కొన్ని అమౌంట్ డిపాజిట్ ఇచ్చిన బ్యాంక్.
Yes, sir.
కొద్దిగా ప్రాపర్టీ ఉంది. పార్టిషన్ సూట్ లో ప్రాపర్టీతో పాటు డిపాజిట్ ను అడగొచ్చా?
అడగొచ్చు.
బ్యాంక్ ను.
But you will have to ask, mention it in the form of Schedule A and Schedule B. The deposits which are there, mention it as Schedule A, and property which is there, mention it as Schedule B.
ఓకే సార్. కానీ దానికి మరి అమౌంట్
కోర్టు మీద కట్టాల్సిందండి. ఎంత అమౌంట్ ఉందో మీ భాగానికి మీరు కట్టాల్సి ఉంది.
ఓకే సార్.
అందుకన్నా చూడండి, దేవుడు వరం ఇచ్చిన ఆ పూజారి అడ్డు వచ్చాడని అది. గవర్నమెంట్ విల్ నాట్ లూజ్ ద కోర్ట్ ఫీ.
Right.
Anybody else? All right. Shall we conclude the class today? For today?
Sir.
Yes. BI.
What's your full name?
Sir.
What's your
కొంచెం కౌంటర్ క్లెయిమ్ గురించి సెటప్ గురించి కొంచెం తెలుగులో వివరించండి సార్.
సెట్ ఆఫ్ అనేది ఏంటంటే, ఇప్పుడు సపోజ్ నేను 10 లక్షలకి వ్యాజ్యం వేశాను, సూట్ వేశాను అనుకోండి. సపోజ్ నేను ప్రతివాదిగా ఉండి నాకు మీరు 6 లక్షలు ఇవ్వాలి నాకు అదే ట్రాన్సాక్షన్లో. అప్పుడు నేను సపరేట్ సూట్ వేసే బదులు దాంట్లో నేను చెప్పొచ్చు, నేను 10 లక్షలు నేను బాకీ ఉన్నాను, దాంట్లో 6 లక్షలు నాకు డబ్బులు ఇవ్వవలసిందని చెప్పి మీరు అది అడ్జస్ట్మెంట్ అడగొచ్చు. దట్ ఈస్ కాల్డ్ సెట్ ఆఫ్. అది దానికి అమౌంట్ వాడు ఎవరైతే వాది క్లెయిమ్ చేస్తారో దానికన్నా తక్కువ ఉంటే అది ఏదైతే మీరు దాన్ని ఇది డిడక్ట్ చేయాలి లేకపోతే మినాయించాలని చెప్తారో అది సెట్ ఆఫ్ అంటారమ్మా. కౌంటర్ క్లెయిమ్ అనేది మీరు అడిగేది ప్లెయింటిఫ్ అని వాది అడిగే దానికన్నా ఎక్కువ ఉంటే అది కౌంటర్ క్లెయిమ్ అంటారు. లేకపోతే ఒక సూట్ ఖాళీ చేస్తానికి దావా వేశారనుకోండి, దాంట్లో మీరు ఏమంటారంటే వాది నాకు 10 సంవత్సరాలు ఇంకా లీజ్ డీడ్ రాసిస్తాను, కిరాయినామా లీజ్ డీడ్ రాసిస్తానని చెప్పాడు, అది చేయలేదు, వాడిని కంపేర్ చేసి అది రాసి ఇవ్వమని చెప్పి మీరు అదే సూట్లో మీరు అడగొచ్చు. అది కౌంటర్ క్లెయిమ్ అంటారు.
ఓకే
రైట్
సార్ వన్ సబ్మిషన్.
యువర్ నేమ్ ప్లీజ్.
సార్ ఈ ముస్లిం సూట్ లో అఫర్మేషన్ అండ్ అఫర్మెంట్ కోసం can you explain briefly?
I'll tell you, sir. As far as Hindus are concerned, మన హిందువులు ఉండగా మనం వీ క్యాన్ టేక్ ఓత్, దేవుడి మీద మన సాక్ష్యం చెప్తాం. కానీ తుర్కోళ్ళు ఎవరైతే ఉన్నారో వాళ్ళకి షరియత్ అని ఉంటుంది. వాళ్ళు దే ఫాలో ది ఇస్లాం, వేర్ దే సే ముస్లిం తుర్కాయనకు ఇది వాళ్ళు ఏమంటారు, దే షల్ నాట్ టేక్ ఓత్, కసం ఖానా అంటారు చూడండి. అప్పుడు వాళ్ళు ఏం చెప్తారంటే ఏదైతే నేను రాస్తున్నానో అదంతా కరెక్టే, దానికి ఏం వ్యతిరేకం లేదు, అదంతా నేను అర్థం చేసుకుని నా పూర్తిగా రాసిస్తున్నాను ఇదని చెప్పి వాడు అఫర్మెంట్ అంటారు. అఫర్మెంట్ అంటే ఎవరైతే మనం ఇది హిందూస్ లో మనం డిపోనెంట్ అంటాం, ఎవరైతే అఫిడవిట్ లో చెప్తారో వాడిని డిపోనెంట్. ఏ పర్సన్ హూ డిపోజెస్ ఆన్ ది ఫ్యాక్ట్స్ మెన్షన్ ఇన్ ది అఫిడవిట్ ఈస్ కాల్డ్ ఎ డిపోనెంట్. But a person who affirms to the facts mentioned in an affidavit is called an affirmant. Affirmant is mentioned only regarding Muslims. But one thing is also there. Most of us believe in God, isn't it? We say we swear in the name of God. But as far as some people, we don't believe in God, then we affirm to the facts because we don't take oath, because we don't believe that we are a rationalist. We don't believe in God. Then we say affirmant.
అంటే ఇప్పుడు సార్ ఇప్పుడు నా కేసులో ప్లేంటిఫ్ సైడ్ లో వాళ్ళు అఫిడవిట్ పెట్టిన తర్వాత అఫర్మెంట్ అండ్ డిపోనెంట్ ప్లేస్ లో అఫర్మెంట్ పెడితే can I specific that point?
You can say Hindu will not be an affirmant unless he is a rationalist, that is who doesn't believe in God.
Hello sir,
a person who doesn't believe in God, a person who only affirms and states facts which are mentioned are true and correct, he is called an he affirms to the facts. He says that the facts mentioned above is true and correct.
Deponent place lo affirmant and pedite can I specify that word before the bench?
You can definitely say a Muslim will not take oath. Muslim cannot be called a deponent. Muslim is only called an affirmant.
Can I bring that to notice to the bench?
You can do it.
Okay sir, thank you.
Welcome.
Mr. Venkat.
Sir.
Yes.
Good evening.
Good evening, sir.
And my doubt is, sir.
Yeah.
One party has filed a suit against its brother, checking partition.
Yes.
In that already they have a partition earlier 30 years back.
Yes.
according to their partition, they have
Divided.
taken position and mutated in revenue records.
Yes.
The plaintiff fellow has alienated the suit property fallen to him, and he has suppressed that fact and filed his present suit against his defendant, his brothers and sisters,
Right.
Seeking partition on the property fallen to the defendants.
That he cannot do. Once the partition has already taken place, he cannot question that partition and file a fresh suit unless he is able to show that he has been given lesser area than that of the defendant. Only in the exceptional cases it can be reopened, not otherwise.
So, is there any limitation for the partition
There's
once again?
There's no limitation, sir.
Oh, okay, sir. Thank you, sir.
Right. Any more questions, please?
All right, we're concluding the class today.
Yes, sir.
Thank you very much. See you tomorrow again. Same timing. Bye-bye.
Thank you, sir. Thank you, sir.
Thank you, sir.
Recording stopped.
Thank you, sir.
Thank you.